atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy.
I'm your host, Jay Carson, here with Justin Holmes, a professor of political science at the University of Northern Iowa. How's it going, Justin?
Yeah, it's going good. How are you today?
Good. We are, again, we're admittedly the B team, but we know that and we own that. On our bonus show today, though, we've got some A-list material that we couldn't cover in the original show. Well, mostly, I think something really big, especially for you TikTok fans. Just yesterday, the Supreme Court issued a decision upholding the so-called TikTok ban, which isn't so much a ban as a requirement that TikTok ByteDance, its parent company in China, divest itself of the company and have domestic ownership. The court unanimously upheld the law with an opinion which I find interesting on some First Amendment grounds. I can say this was as I expected, although I expected it might have even gotten like the higher level of scrutiny, but still passed. But this, we're going to be talking about, one, the decision, how that came about, and then sort of the political fallout from it. And then we've got other tech and internet decisions coming out regarding the Free Speech Coalition's argument in the Supreme Court about obscenity in pornography and age verification. And then lastly, I think we've just got sort of a grab bag, as you will, right, of other things, new constitutional amendments that kind of took everybody by surprise, and other fun stuff. So I'll lead off, I guess, with the TikTok decision. This was sort of a long-awaited, and people sort of on pins and needles as to whether TikTok will remain viable or go dark. TikTok at this point says it will go dark as of Sunday, I believe, but that remains to be seen. This decision involved a law that prohibited companies, not just TikTok, but TikTok was the one everyone was talking about when this passed, which are owned by adversary states, which would include China, from being able to be owned by these adversary states and have these connections with these foreign governments. Notably, the problem is that TikTok parent company ByteDance is a Chinese company, and the Chinese have a law saying that all Chinese companies will cooperate with the government and the Chinese Communist Party in collecting intelligence. It literally says that, and that's not even just sort of that there might be some sort of okay sort of pressure to help out. They're required by law to do this and enlist themselves in intelligence gathering. That enough members of Congress deemed that to be a national security threat to pass this law that would require companies like ByteDance to sell off TikTok and in order to prevent that unwanted intelligence gathering and other potential malicious uses by what Congress has defined as an adversary power. The bill was signed into law by President Biden, and TikTok brought suit, and it went, not surprisingly, to the U.S. Supreme Court. We had talked about this, I think we being Mike and I, way back when this first started. I pointed out, I think there are obviously significant First Amendment issues, because when you regulate a platform, you're regulating speech. The question then comes down to in what way are you regulating speech, and what level of scrutiny the Supreme Court will, or any court, will give to that regulation. So, Justin, have I got it right so far?
All sounds good to me.
Yeah. So briefly, again, and if I'm getting too in the weeds nerdy, Justin, interrupt.
I feel like that's our brand, though.
Well, I think it is too, but you never know.
Yeah, fair enough.
So for most of our listeners, you will know that the way courts determine to make these decisions, there's this rubric, right? There's this system of different levels of scrutiny that courts will apply to legislative actions when determining whether or not they are constitutional. Now, this method of deciding this is completely made up, to use as the I think official political science term, but it's the system we've had and used for well over 100, 150 years since we started thinking about how we evaluate these things, and the idea that, listen, you have certain constitutional rights, but no rights are absolute. So how do we go about drawing the line? And I think this is something that often gets overlooked by the media in discussing these things. But that's why you've tuned into us, and you can get the extra smart version and impress your friends by explaining the various levels of scrutiny. The lowest level of scrutiny is what's called rational basis scrutiny, where the court will look at a law and they will say, well, look, if there's any rational basis for this to be passed, if Congress can come up with any halfway plausible reason why this ought to be passed, even if it's a bad reason, even if it's a very dumb idea, even if it wouldn't hold water politically, even if it's nonsensical. I shouldn't say nonsensical, because I suppose that would.
There's still a standard of review.
Yeah. The way the system shakes out is under rational basis review, almost everything is going to be constitutional. So a rational basis review you get for your run-of-the-mill garden variety statute, right? When you start getting into statutes that implicate what are called fundamental rights, then these other review standards start to kick in. So you've got intermediate review, which is typically applied in sex discrimination cases. The idea being, well, listen, yeah, there could be a rational basis, but there's still a little bit suspect, right? So what they have to show is that there's some important government interest that's being protected, and there's got to be some sort of tailoring of the means to meet the ends. It can't be completely loosey-goosey. It's got to be sort of a sensible thing. So we're going to take a little tougher look at that. So the example, I guess, of intermediate scrutiny is, say, in discrimination cases and sex discrimination on one of the big cases, let's say firefighters, right? Where you can say, listen, there are certain physical strength qualifications that people need to meet, male or female, in order to do the job. Therefore, even though those qualifications may make it more difficult for females to get that job, there's still a using intermediate scrutiny, the means fit the ends, right? They're narrowly tailored because, look, there is a legitimate government end in making sure that your firefighters are fit to do what they need to do. So the next level up then you get is what's called exacting scrutiny, which no one's exactly sure what exacting scrutiny means, but the place where you see that, and the place where you saw that most recently, the Americans for Prosperity Foundation versus Bonta, which had to do with associational rights, also NAACP versus Alabama, in both cases in which the government wanted to sort of keep a list of nonprofit organizations and its members just to, protect against stuff like fraud and whatnot. Although it was never really exactly clear what the fraud was or what they're protecting against. If you read the case name of NAACP versus Alabama and know that it was decided in 1958, that'll give you a sense of what was going on. And in that case, the exacting scrutiny, the court says, look, there's got to be an important, government interest, significant government interest, and a substantial government. I keep, even I goof these up, and I'm doing this without my script. Government interest, and the means to meet that have to be narrowly tailored to the ends. And in those cases, the Congress said, no, the remedy you've proposed of taking names and keeping a list is not narrowly tailored to defend against fraud that you think might be a problem. The toughest level is what's called strict scrutiny, and most laws that are subject to strict scrutiny almost always get overturned. Strict scrutiny is typically a death sentence, and that you have to have a substantial government interest. You have to have a very tight means ends fit. And in fact, the means that you accomplish your end have to be the least restrictive means to do so. And that's where you get into cases where in typically speech cases, other fundamental rights cases, that they are, it's almost the death knell, right? So with all that, what the Supreme Court said here was they applied the intermediate level, saying, one, the restriction that is in the law certainly impacts speech, but it's not a content, it is a content neutral regulation, right? There's nothing claiming that you can't say a certain thing on TikTok. It's just a matter of the platform and who owns it. So therefore, while it impacts speech and there's a First Amendment piece to it, you have to go through the analysis, but it's the intermediate scrutiny level. And upon applying that intermediate scrutiny, the court found that, yes, there is a substantial government interest in national security that applies beyond just people who happen to use TikTok, right? There's this idea that, listen, if you as an American, even if you aren't on TikTok, and I'm not, the fact that the Chinese government may be getting information from somebody else surreptitiously harms you as an American, harms the country as a whole. So therefore, that's what they're going to apply. And then you look at the means and the ends fit. And the court, with a couple of concurrences, which are interesting, I want to say is one of the ones that they use the phrase that we don't want to embarrass the future. The idea that, look, there may be in the future some better means to do this, right? To protect data privacy from foreign adversaries without requiring the sale of a company. But that's what we've got right now, and that's what we've got to go with. So again, I think it's an interesting. Anytime there's a 9-0 Supreme Court case on something that's fairly visible, right? There's more 9-0 cases than a lot of people realize. But on something that gets a lot of press, it is maybe a little surprising and something that people thought was perhaps more controversial than what it was. Justin, your thoughts? I've rambled way too long, but that's your constitutional law lesson for the day.
Yeah, and why I don't do constitutional law. So, it's interesting. In fact, I learned about a whole new level of scrutiny that I had never known about.
Exacting one? Yeah, you don't hear about it much.
You don't ever hear it, yeah.
I mentioned that only because there is an outstanding amicus brief filed in the CTA matter that talks about exacting scrutiny. But yeah, and the other thing, quite honestly, this is the other where constitutional law is an imprecise science, is that if you're really called upon to ask someone to, well, what's the difference between a significant government interest, an important government interest, a substantial government interest, no one would really be able to tell you that.
Yeah, that's the kind of thing. I do a little bit of constitutional law in my intro classes, and the one that I always come back to that is Lemon v. Kurtzman, where the language
Lemon
there,
test.
The Lemon test, which on kind of the face of it sounds like, okay, this is all plausible, and then you start thinking about, okay, but how do I quantify any of these or measure any of these things?
The Lemon test has to do with religious establishment
in public schools, and basically part of one of the prongs is there should not be too much entanglement between religion and kind of like, well, that kind of begs the question for that this asked in the first place, which a lot of these scrutiny things I get that same feeling is that I can't define any of this particularly well, and conceptually it all makes a lot of sense. What this looks like in practice seems a little in terms of what counts as evidence and what doesn't.
We hope you enjoyed this preview of our supporters exclusive midweek show. If you'd like to hear the rest of the episode, we hope you'll consider becoming a supporter. Supporters get ad-free access to all of our shows, membership in our Politics Guys Discord group where you can join in on the conversation, and other benefits at different levels of support. To become a supporter, go to patreon.com/politicsguys. You can also support us through Venmo or @politicsguys or through PayPal. You'll find all of our support links in the show notes as well as at politicsguys.com/support. And if you'd like to get the midweek show, but you're not in a position to become a financial supporter, that's not a problem. Just send me an email at mike@politicsguys.com and I'll be happy to get that set up for you.
This podcast is part of the Democracy Group,